In contracts, obligations are the heart of the agreement. They explain what each party is expected to do and what is not allowed. A client or colleague may ask, "What is my duty under this contract? What happens if the obligation is not fulfilled?" In today's lesson, you will learn the key vocabulary for obligations and you'll practice two useful grammar structures: be supposed to for expectations and must not for prohibitions. These will help you explain contractual duties in clear English. This is part of our full legal English course for lawyers and professionals. For full lessons, live sessions, and expert support, join our legal English community. The link is in the description. By the end of today's class, you will use beginner level vocabulary like duty, performance, breach, penalty, liability, and compliance to describe obligations. Use supposed to explain what someone is expected to do. Use must not to explain what someone is not allowed to do. And apply legal phrases such as breach of contract and penalty clause to explain real obligations in simple English. Imagine this. Two companies sign a sales contract for the delivery of office furniture. The buyer is a large office and the seller is a furniture company. Both want to understand their obligations clearly. The buyer asks, "What are my duties in this contract?" The lawyer explains, "You are supposed to pay the price on the agreed date by bank transfer. This is your payment obligation." Then the seller asks, "What happens if I do not deliver the furniture on time?" The lawyer replies, "You must not delay the delivery. If you do, it is a breach of contract." There's also a penalty clause that requires extra payment for each late day. Finally, the buyer asks, "And if I want to cancel the agreement?" The lawyer explains, "You are supposed to give written notice 30 days before. That is part of the notice period in the contract." This story shows how lawyers explain obligations step by step. What duties exist was, I'll let go up for a second, just very little. What duties exist, what must not happen, and what penalties apply if the contract is not performed. A duty is a legal responsibility in a contract. It is something you must do because the contract requires it. For example, the buyer has a duty to pay the price. Imagine a delivery contract. The seller has the duty to deliver the goods. The buyer has the duty to pay the money. If either side does not respect the duty, the contract is broken. When explaining this to a client, you might say, "Your duty under this contract is to provide the service by the date. The other party's duty is to make the payment." Duties are the foundation of all contracts. Performance means doing what the contract says. For example, the contract is valid when performance is completed. A construction contract. Let's imagine. The builder must finish the house. The client must pay for the work. When both sides do what is required, the contract is performed. A lawyer might explain, performance means the seller delivers the good and the buyer makes the payment. Once both duties are done, the contract is performed. Performance is about action, not just promises. A breach happens when a duty is not respected. For example, there is a breach if the goods are not delivered. Let's look at an example. A rental contract says the tenant must pay on the first of the month. If the tenant pays on the 15th, there is a breach. In business, breaches are serious because they lead to penalties or damages. A lawyer might explain, if you don't perform your duties, there is a breach of contract, and the other party can claim compensation. A penalty is the punishment in a contract if someone does not respect an obligation. For example, there is a penalty for late payment. Let's imagine a buyer agrees to pay on June 1st. The contract says if payment is late, $100 extra must be paid. That extra $100, the penalty, this helps ensure compliance. A lawyer might say the penalty clause is there to make sure the parties respect their duties. If not, they must pay more. Liability means legal responsibility when something goes wrong. The seller has liability for defective goods. Let's look at an example. A company sells software, but it does not work. The buyer loses money. The seller has liability. This means they are responsible for fixing the problem or paying damages. A lawyer might explain if the service fails, the company has liability. That means they must repair the mistake or pay compensation. Liability protects the party who suffers the loss. Compliance means following the rules written in the contract. For example, compliance with safety rules is required. Let's look at an example. A factory contract says all workers must wear helmets and gloves. If the company enforces this and workers follow it, there is compliance. If not, there is non-compliance. A lawyer might explain compliance means you are doing what the law or contract asks. Non-compliance can lead to breach or penalties. This word is very common in contracts about health, safety, and regulations. A payment obligation is a duty to pay money by the agreed date. Let's look at an example. There is a payment obligation on the first of every month. Let's look at an example. A tenant rents an apartment. Their payment obligation is $800 every month on the first day. If they do not pay, the landlord can say there is a breach of contract. A lawyer might explain the payment obligation is clear in this contract. You must pay on the date or there will be a penalty. This phrase is simple but essential. A notice is a formal communication between the parties to a contract. For example, notice must be given before ending the contract. Let's look at another example. An employee wants to resign. The contract says they must give 30 days notice. The worker sends a letter to the employer. That letter is the notice. A lawyer might explain, notice is very important. It shows the decision clearly, and it proves that the party respected the terms of the contract. Without notice, actions like termination may not be valid. Be supposed to means expectation or duty, but it sounds softer than must. Look at the three forms. I am supposed to give 30 days notice. This shows what I personally must do. The buyer is supposed to pay on time. This is the buyer's duty in the contract. The sellers are supposed to deliver the goods. This shows the obligation of more than one seller. Now, let's look at some more examples. A lawyer is explaining to a client. They say, you are supposed to sign the contract today. The buyer is supposed to transfer the money tomorrow. The workers are supposed to follow the safety rules every day. This structure is very common in contracts and daily life when describing what someone is expected to do, without sounding too strong or formal. Must not is used to show something is prohibited. It is not allowed. The worker must not share confidential information, or the buyer must not cancel without notice. Let's look at another example. A contract says the tenant must not sublet the apartment. This means renting to another person is prohibited. This structure is very important for obligations because contracts often say not only what you must do, but also what you must not do. To fulfill an obligation means to do exactly what the contract requires. The seller fulfilled the obligation to deliver. Let's look at an example. A contract says the seller must deliver 500 chairs by June 1st. On that date, the chairs arrive at the buyer's office and the buyer receives them. The seller has fulfilled their delivery obligation. A lawyer can explain this to a client. When you pay the invoice on time, you fulfill your payment obligation. When the supplier delivers the goods, they fulfill their delivery obligation. Once both sides fulfill their obligations, the contract is complete. This phrase is very common in legal English because contracts are built on obligations that must be fulfilled. A breach of contract happens when one party does not fulfill their obligation. Let's look at an example. There is a breach of contract if the goods are not delivered. Now let's take a look at a story. A company signs a contract to provide cleaning services every day. After 1 week, the company stops sending workers. The client can say, there is a breach of contract. A lawyer can explain it this way. If you don't perform your duty, like paying on time, delivering as promised, or giving proper notice, it is a breach of contract. Breach usually means the other party has the right to claim damages or apply penalties. This phrase is one of the most important in contract law, and it's essential for explaining risk in simple English. A penalty clause is a section in the contract that explains what happens if there's a breach. It usually means extra payment or another consequence. For example, the penalty clause requires payment for late delivery. Let's take a look at a story. A builder must finish a house by September 1st. The contract says if the house is late, $200 per day must be paid as a penalty. On September 10th, the house is still not finished. The builder must pay $1,800 under the penalty clause. A lawyer might explain this clause here is to pressure both sides to respect their obligations. If you fail, the penalty clause applies automatically. This phrase is useful for lawyers because it explains not just the duty, but also the consequence of failing the duty. A notice period is the amount of time one party must give before ending a contract. There is a 30-day notice period for ending the contract. Let's look at an example. A tenant wants to leave their apartment. The lease says notice must be given 30 days before moving out. The tenant sends a letter to the landlord 1 month in advance. That letter is the notice, and the 30 days is the notice period. A lawyer might explain the notice period protects both parties, gives time to prepare. In employment contracts, workers often have to give notice before resigning. In leases, tenants must give notice before leaving. Without notice, ending the contract can be a breach. This phrase is essential because many contracts cannot be ended immediately. Notice is required. Let's finish with the full story that brings everything together. Two companies sign a contract for the delivery of 1,000 chairs. The lawyer explains the obligation step by step in simple English. First, the lawyer says, the duties are listed in the contract. The buyer has a payment obligation, and the seller has a delivery obligation. Next, the lawyer turns to the buyer. You are supposed to pay the price on the first of the month. That is your duty. If you pay on the date, you fulfill your obligation. If you do not, there is a breach of contract. Then the lawyer speaks to the seller. You must not delay delivery. The chairs are supposed to be delivered by June 1st. If you deliver late, the penalty clause applies. You will have to pay $200 for each late day. The lawyer also explains liability. If the chairs are defective, the seller has liability. That means the seller must repair or replace them, or pay damages. Finally, the lawyer reminds both parties about ending the agreement. If either side wants to cancel the contract early, notice must be given in writing. The notice period is 30 days. This gives time for both sides to prepare. By the end, both sides understand their obligations clearly. The buyer is supposed to pay on time. The seller must not deliver late. Penalties are applied if there is a breach. Notice is required before ending the contract. This story shows how vocabulary, grammar, and legal phrases work together to explain real obligations in contracts clearly, simply, and professionally. Let's review today's lesson on contract obligations. First, we practice vocabulary. Words like duty, performance, breach, penalty, liability, compliance, payment obligation, and notice. These words help you explain the building blocks of a contract. Second, we studied grammar. You used be supposed to for expectations. The buyer is supposed to pay on time. And you used must not for prohibitions. The seller must not deliver late. Third, we worked with legal phrases such as fulfill an obligation, which is to complete what the contract requires, or breach of contract, which is failure to respect an obligation, penalty clause, the punishment written into the contract, as well as notice period, the time required before ending the contract. Finally, we finish with a wrap up story about a sales contract. You explained buyer's duties, seller's duties, what happens if there is a breach, how the penalty clause works, and why the notice period is important. Now you can describe contractual obligations step by step using simple English that is clear, accurate, and professional. Contract obligations are at the center of legal practice. In our legal English community, you get full access to beginner, intermediate, and advanced lessons, plus live sessions in a private forum with other lawyers. Click the link in the description and join us today to keep building your legal English skills.